Welcome back. Thanks for staying with us. Suspended Public Protector Busisiwe Mkhwebane has once again called on the chairperson of the Parliamentary inquiry into her fitness to hold office, Qubudile Dyantyi, to voluntarily recuse himself from the committee. Dyantyi had ruled when Mkhwebane first made the demand that she lodges a formal written application for his recusal to allow him to respond formally. She has, however, sent him a new letter through her lawyers demanding that he voluntarily recuses himself. Dyantyi has replied, however, that without a formal written application, he will not consider the request for his recusal. We are now joined by senior legal analyst Adv Romeo Nthambeleni to speak to this matter a bit more further. Advocate, thank you so much for joining us here on the late edition. One would ask, when we look at that press briefing that took place today, what do you make of these allegations which have been presented by Advocate Busisiwe Mkhwebane, saying that there were attempts to solicit a bribe from her?
Good evening to you, Mbali, and the viewers, and thanks for having me. In a direct response to what you are saying, with what we have witnessed earlier this afternoon today, there is a principle in Roman Dutch law which says nemo judex in sua causa, which means that you cannot be a judge in your own case. So what has actually happened today in that gathering was that evidence was presented, and then the court of public opinion was actually asked to weigh in on that evidence that was being presented. And that is where we have a danger of one being a judge and a jury and an executioner in their own case. I think that is what transpired earlier in this afternoon today.
And would you say, Advocate, with the evidence that has been presented, is it enough, to take this on a legal basis and to actually have a criminal case here?
Yeah, it's a very good question that you're actually asking, and it needs a legal answer. And the legal answer is the test of admissibility of evidence under the law of evidence. And the first point of departure is that when you record someone, that person that you're actually recording must be aware that you are recording them. And then in the absence of their knowledge, the evidence that you're actually going to present becomes what we refer to as inadmissible evidence. So that is the first point. And then there is also an issue of hearsay evidence that the court actually accepts to a limited extent. And because this is second-hand information that comes from a person who has recorded that recording, not the presenter himself, that information falls in that category of hearsay evidence that the court actually accepts under very limited circumstances. The other important principle that we must look at is that the person who was recorded is deceased and will not be subject to cross-examination to actually test the veracity of the evidence that is being presented against her. So I think that is where that evidence that has been presented have challenges.
So are you saying that this evidence can't be used in a court of law?
It's inadmissible evidence. And I said that the test of inadmissible evidence and hearsay evidence, the court applies very strict test because in the normal circumstances where evidence is brought before court, it must be corroborated. And then the court takes very unkindly evidence of a single witness. So insofar as we are concerned now, it's going to be an evidence of a single witness because there's no a second person that is going to be cross-examined on that evidence who actually was the person who was interviewed in that recording. And it falls under inadmissible evidence. And I said the court actually accepts hearsay evidence in very limited cases, not each and every case the court accepts hearsay evidence. So the test is very high on the admissibility of hearsay evidence in court. So now we're dealing with the recording that was taken first with the person not being aware that they were being recorded. Secondly, the person is not there to actually defend the contents of the recording and the contents of that recording. Then that surely falls the test of what evidence is in terms of the law of evidence in South Africa.
And, can the latest developments play any role here for the inquiry, which is actually underway in Parliament? Can these developments actually affect what is taking place in Parliament?
Yeah, look, the process has been somewhat tainted. You cannot deny that. And then the fact of the matter is that where the proper channels used to actually bring this evidence to the fore, the committee has requested that that evidence be presented to the committee and then be investigated thoroughly so that an outcome will be given. And I don't know what was the purpose of actually bringing the evidence to the court of public opinion, where it's not going to be interrogated by the people that are tasked with the responsibility of determining its veracity and also the criminal investigation. So I think that was a little bit of jumping the gun and also not following the processes as directed by the parliamentary committee that is seized with the responsibility of actually conducting the whole investigation in this inquiry. So the long and short of it is that the process has been tainted, unless there's an independent investigation that is conducted and exonerate those people that are alleged to have interfered with the processes as alleged by the suspended public protector.
And of course, these claims that the suspended public protector has brought, before the public, one would ask, she has always said that, she is being victimized here, she is being targeted, with these new claims now, which, she has brought to the public. One can also ask that she is playing in that narrative once more of questioning the public, that here we go again, I am being victimized, and here are people who are involved in trying to solicit a bribe from me, but nothing is being done about it.
No, you're quite correct. But unfortunately, it's a parliamentary process, and then it must be dealt with by Parliament, and every allegation that is being put forward must be taken to Parliament, not to the public. The public are not seized with the powers to investigate her fitness to hold office, and the public will obviously give one opinion or the other, but that opinion that is being given by the public does not carry any weight whatsoever, because what is being done is a parliamentary process that has got prescripts and the rules and the guidelines of Parliament that is supposed not to be followed. But you are correct to say that it plays to the public opinion and the issue of public sympathy of victimization. And as far as I'm concerned, you allow the processes to unfold, and then when a finding has been made one way or the other, you have the opportunity to actually review the proceedings if ever there is challenges that you want to actually bring against the entire process.
An advocate, one would also ask that we can see that, the advocate here is really trying very hard to challenge the allegations which have been presented, be it, the allegations of this bribe. Why is it so important for her to continue on this path and to challenge, what she says is an unfair process against her? Why is it so important for her to remove herself from this inquiry?
You mean the chairperson of the inquiry?
No, I mean Busisiwe Mkhwebane.
Okay, yeah, I didn't get that question actually clear. So, if you are talking about the suspended public protector, as I've actually said, when you are involved in the process yourself and then bring evidence to actually point to the other direction, it doesn't help you, and unless there's an independent finding that is actually conducted by an independent person who looks at the evidence that has been presented and determine its veracity against all in a process that is fairly conducted. So if you are supposed to be the one that brings that very same evidence, it actually talks to the very same issues of saying that there is supposed to be an independent person that looks at this process and make a determination on whether there is substance in the information that has been brought. And that's why I started by saying that there is a danger in one becoming a judge in their own case. We reach to a point where we are at the moment.
And lastly, should Parliament resort to actually asking Dyantyi to remove himself from this inquiry? One would ask, what will it mean for the inquiry against the public protector?
No, what you're saying is important there. When you started, you indicated that he has requested a substantive application to be brought for his recusal. And then when you bring a substantive application, that is where you air out your case that was being done in the public. And then the chairperson himself make a determination. And we've got rulings on the Constitutional Court in relation to these matters of recusal. And, one will follow those as authority to be able to make a determination whether the recusal is founded or is unfounded. And that is where these issues are properly ventilated through a proper application, or a substantive application that is brought for recusal of the chairperson. And without that, as you have correctly actually said, that the chairperson has to actually proceed with his duty and finalize the process as mandated by Parliament.
All right, Advocate, thank you so much for your time, and thank you for joining us here. Of course, that is Advocate Romeo Nthambeleni, the legal analyst, just talking about the issue when it comes to the suspended public protector.